Thank you, everybody, for being here with us tonight and taking time. Evidently, there's some storm on its way, so we hope to be, it'll be a little this much rain probably, but nonetheless, that's what they're predicting, so we hope to get everybody out of here in time. But thanks for coming tonight and being part of education policy. And again, as always, unless you have a question specifically for that testifier, and if it can wait, we prefer to get through all the testifiers before we open it up for questions and comments. So with that said, Senate File 617, Senator Kunesh.
Thank you, Mr. Chair. Mr. Chair and members, this bill addresses or does action on the Office of the School Trust Lands. And if you were in my Finance Committee, you would have had a full explanation of the school trust lands. But what this bill does is that it modifies several provisions related to the school trust lands director's position in Minnesota statutes. The school trust lands director position was established in 2012 to provide recommendations to the executive and legislative branches about the management of the the state's schools trust lands. The proposed legislation would accomplish the following. It would address two recommendations from the Office of the Legislative Auditor's 2020 Special Review of School Trust Lands Management Report. It would provide clarity by requiring school trust land director to act as a fiduciary capacity for school trust beneficiaries. It provides transparency by reorganizing the duties regarding the director's advice and recommendation requirements, also the reporting requirements and other key duties. It provides uniformity with other executive branch appointees by removing the oath of office requirement, and again provides flexibility by reducing restrictions on the director's ability to hire and retain employees. There is no fiscal impact on this bill, and I would like to invite Director Vandelin to come up and talk a little more about this legislation and the role of the school trust lands. Good evening.
Begin and identify yourself and make sure you sign the register before you're done. Thank you.
Will do. Thank you, Mr. Chair. Aaron Vandelin, School Trust Lands Director. Thank you for the opportunity to speak in support of Senate File 617 this evening. Just a little bit of history around this bill. As Senator Kunesh already identified, it was part of the OLA report, and that's what really prompted us to seek some statutory changes in our duties. I should say this doesn't change any of my duties as the school trust lands director. I have the same duties in the statute. It just simply reorganizes them so it's clear that we have duties to the executive branch and duties to the legislative branch. Right now they're a little commingled in the statute. We just wanted to clean that up. I could walk through it section by section if you'd like, Mr. Chair. Otherwise, I just say that this bill's been around for a couple of years. It did pass last year, and it was in the omnibus bills. It just did not get a vote as a lot of bills last year.
If you'd like to point out the key components that you'd like to bring to our attention, but I don't think it's necessary for you to walk it step by step.
Thank you. So the second page, lines 2.14 to 2.17, those were recommendations from the Office of Legislative Auditor to clarify what the director's role is when there are internal land exchanges or condemnation proceedings by any state agency. So that was the first one. The second recommendation from the OLA is on lines 3.15 to 3.18. And this is legislation that was added to my duties after it was first passed in 2012. This was a Representative McNamara-led initiative. Wanted to see the school trust develop some of its real estate assets and gave that authority to the director. We recognize that the director does not have authority to make those management decisions. I'm in an advisory role to the executive and legislative branch, so we're clarifying that we do that in conjunction with the Department of Natural Resources. And then the final thing that I would like to point out is back on line, let's see, 3.11 and 3.12. My staff right now, we have a very small office, 2.5 of us, including myself. So my 1.5 staff serve in unclassified service. I've been told that has a term limit of 5 years. So I will have to be rehiring my staff. Changing it to classified service doesn't change any of their rights or under the contracts, as I've been told. And it just gives me some flexibility to keep my staff employed and keep some continuity in the office. Those were the keys that I wanted to point out, Mr. Chair.
Thank you. Questions, comments, members?
Senator, or Mr. Chair, I'm just wondering if everybody knows what the school trust lands are.
Tutorial, please.
I am going to ask
Before we get the tutorial, evidently I misled everybody. The storm is coming early in the morning. So if your stress level was elevated because of my remarks, I apologize.
I would like to ask the director to just give us the quick lowdown on how these school trust lands came into being and what our responsibility as legislators are when we direct you to manage those lands, please.
Mr. Chair, thank you, Senator Kunesh. So I'll just put it bluntly. I have a problem with that sometimes, but anyone that is making a decision on school trust lands has to act in a fiduciary responsibility. That means on behalf of the trust and only the trust and its beneficiaries. So that includes every legislator, the governor's office, and every executive branch agency, including myself, that makes decisions on school trust lands. So we all have to act on behalf of the trust when we're making these decisions. The way the statute reads is we have to manage for, the goal of the permanent school fund is to secure the long-term maximum economic returns from the school trust lands with our, by using our fiduciary responsibilities with sound natural resource and conservation management principles. So what I think that means, and the way we implement it, is we try to balance revenue enhancement with resource stewardship. So this is a perpetual trust. It has been in existence since 1858. The lands that we have today, 2.5 million acres, were reserved from federal grants when we became a state and after statehood. So this was, I would say, Thomas Jefferson's brainchild in the General Land Ordinance from 1785. Those lands were reserved for Minnesota and other states as they came into the Union. Minnesota received Section 16 and 36 in every township. We ended up, after the 4 federal grants, with about 8.1 million acres. We have 2.5 million acres left. Most of the land in the southern and western part of the states has been sold for farming, more or less. As I said, the trust has a 2.5 million acre asset plus another 1 million acres of severed mineral rights. And the trust also has a fund that is actually how we get money to education. That fund is worth $1.7 billion. This school year, it resulted in a distribution. This is, I think, the largest distribution we've had, $39 million across all the school districts. It's based, the school districts get that money in September and March, and it's based on their ADM. Did I need to go?
No, you did great. Thank you. All right, I have no other comments to make other than I would ask you to support and move this Senate File 617 forward.
All those in favor for laying the bill over? Oh, okay. So moved.
Oh, so moved.
Okay. Senator Kunesh, next bill.
Thank you.
Thank you.
So this is a bill that is very near and dear to my heart. This bill, Senate File 1911, would create a school library aid and appropriate money for school libraries. We don't have that at this time. As a library media specialist for the last 20 years, I really got to the core, the nucleus of what it is to be a librarian in an elementary and middle school. And while at one point, not only the state, but our school districts were very supportive of our school libraries, that has started to go by the way. And in fact, I have been texting back and forth with somebody from one of the schools that I have, and there's a bit of a mess in their library. I'm not quite sure what it is. But what this bill does is, as I said, create school library aid, and it appropriates money for that aid. So in the next year, school year, there would be aid that would go to a school district or a charter school, and the formula would equal greater of 15 times the district's adjusted pupil unit for the school year, or $50,000 to that school. And the school, those dollars must be reserved and used for directly funding the costs of purposes within our school library. So the salary and the benefits of the school library media specialist, electronic, computer, and audiovisual equipment, information technology infrastructure and digital tools, electronic and material resources, or furniture, equipment, or supplies. And I can tell you that for much of the time that I was in the library, we had, especially at the middle school, I was at the furniture was old, outdated, was broken, had carving in them, you know, the tables and the chairs. And it wasn't until we spent almost 2 years writing a grant that I was awarded a very large grant and was able to purchase the kind of furniture and furnishing that my students really reacted in a positive way. We were able to put little coffee tables, you know, the tall kind of cafe tables with tall chairs in there, bright colors. We're able to paint the walls, and all of this really added to the ambiance of learning and the excitement of literature and books. It's, you know, it's amazing. I think we all know what a coat of paint will do to lift a spirit. So these dollars would go into that purpose of assisting our school libraries, and I would ask for your support. You all have a handout here, and we have a couple of just wonderful testifiers. So maybe Kim would go first. I'll go first.
Mr. Chair, members of the committee, my name is Kim Haugo. I'm the Library Media Specialist at Maple Grove Senior High. I'm here on behalf of the Minnesota Library Association to ask your support for Senate File 1911. I'm a public school teacher holding both a classroom teacher and media generalist licensure. I love what I do, and I've been a teacher since 1992. Most people have fond memories of their school library and class visits to check out books, but few understand the rigor and training of school librarians. In our preparatory courses, there are a wide variety of requirements, like understanding how to evaluate and select books for children and teens, learning strategies to teach research skills, including the importance of fact-checking. Preparation also includes learning to assess the educational value of software and online systems and how to teach others to use them as well, and learning how to foster the joy of reading via book talks and curating a collection of materials where all students find themselves represented. School media specialists are lifelong learners, a skill we model each day for our students. Unfortunately, not every Minnesota K-12 student has a school librarian. State leadership needs to understand the fundamental role of licensed school media specialists, especially in this age of ever-present information flow. The school library is the heart of the school, and when led by a licensed school media specialist, all students and teachers have access to someone to teach the ethical use of information, a technology integrator, a leader trained in literacy, a computer science teacher, a curriculum developer, and a lesson plan collaborator. Every student in Minnesota needs access to such a teacher and a resource. So I ask, do you want students to have access to age-appropriate resources, to be critical thinkers, to learn how to tell the difference between facts and misinformation, to perform better on standardized tests, and to understand the importance of digital safety and wellness in today's social media world? Do we want teachers to have support integrating technology into the classroom and have teaching partners? Then let's provide a pathway for more districts to staff a licensed school media specialist. They're licensed teachers, specially trained to select age-appropriate resources for libraries and teach research skills. Their impact is far felt as research supports a positive correlation between a licensed media specialist and standardized test scores. Media specialists stay up to date on tech trends such as AI and ChatGPT and share their knowledge with others in the learning community. And they collaborate with classroom teachers to teach Minnesota state standards. Thanks for your time and commitment to Minnesota scholars.
Thank you. All right, and our second testifier is Ashley Crone. If you would like to, oh, you go ahead.
Mr. Chair and members of the committee, my name is Ashley Crone. I am currently a library media specialist for Edina Public Schools, and for the previous 8 years, I managed the 67 library media centers for Minneapolis Public Schools. I'm here today to tell you what every Minnesota student and educator deserves and how you can help them achieve it. Imagine a Minnesota where each and every pre-K through 12 student has equitable and barrier-free access to current high-interest reading materials that reflect their local and global communities. A Minnesota where students are taught to critically analyze multiple forms of information to come to their own conclusions. Imagine educators who are trained in current information and digital literacy standards and technology to prepare students for their present and future, not our past. A Minnesota where students are utilizing existing digital skill sets from gaming and social media and expanding that knowledge for creation and information-seeking purposes to become more engaged participants in society. How do we get there? By ensuring every Minnesota school has a licensed library media specialist. Decades of research prove that all students achieve when a school library program is led by a licensed library media specialist, regardless of socioeconomic status. But there is an even greater impact on our students of color, our students experiencing poverty, our students receiving special education services, and our students receiving ELL services. Yet it is these students who are most often denied a library program. With the achievement and opportunity gaps in Minnesota, it's almost comparable to educational malpractice not to pass the proposed legislation. The power of a school library program run by a licensed library media specialist is that it connects to and enhances all learning for the entire school community. Every Minnesota student deserves this robust educational experience. In the mid-90s, Minnesota repealed the requirement for a library media specialist. An educational debt has been accruing ever since. We must restore our state's history of strong library media programs. You have the opportunity to benefit each and every Minnesotan. I implore you to pass this legislation. Please give students and educators what they deserve, so together we can create the Minnesota that we all deserve. Thank you.
Members, questions, comments? Senator Duckworth?
Thank you, Mr. Chair. Just one quick question. On line 1.14, when it's talking about uses of school library aid, it says electronic and material resources. Does material resources include books? Okay.
Mr. Chair. Yep, it does. It would be the library books that are in the library, the fiction, the nonfiction books, magazines, journals, those sort of things.
Very good, thank you.
Well, I have a question for the two of you. What made you go into this line of work?
That's a great question. I went to college to be an elementary education teacher. And when I was there, I started taking some classes, and they're like, have you ever thought about being a librarian? And I'm like, actually, I used to love my school library, Miss Britnell, and the library that she provided, and it was such a great experience and good memories going back to my elementary school years in central Minnesota, Randall, Minnesota, the only elementary school there. And I was like, yeah, I think I'd like to work in a library. And I ended up getting both degrees. So that's how I started. I've never left.
I actually did my undergraduate degree in film, and I had wanted to make a positive impact on the world. And at the time, I realized that making film or documentaries was a little bit more of the caboose of the train, and I wanted to be closer to guiding that. And so after traveling abroad, I came back to Minnesota and decided to start substitute teaching. I visited a few of my favorite high school teachers who I'd always been inspired by. And it led me to a place of wanting to become a teacher. I actually started out wanting to be an English teacher and had mostly completed my first master's degree before I got a job assisting in a school library with a licensed library media specialist in North Minneapolis. And it was through that experience and actually being put in charge of revamping this elementary school library program that I realized, no, this is what I want to do. I want to be able to impact students' lives through literature, through research, through technology, and help them make the world what they want it to be. And every single day, I am excited to go to work and to be a small part of helping to impact students become the people that they want to be.
I'll tell you my story, too.
Thank you.
Yes, I knew you were going to ask that next. So I grew up in what was then the village of Sartell, and there was a gas station, a little corner store, and the post office. And there was nothing else there for us to do, and my father worked in St. Cloud, so he would go to the library and bring home stacks of books for us. I grew up in this really large family, and he got to, he'd bring home this stack of books, and he'd say, oh, Mary, you'd like this one, or Jim, you'd like this one, Patrice, you're gonna like this one. My parents were avid readers. So I grew up loving books, and it was in the summertime when the bookmobile would come to our little village, our little town, and we could climb up there and exchange our books. And I just knew that I wanted to be a librarian from a very, very young age, not just because I loved books, but I loved to be able to share them and read a variety of books. So as I decided what my career would be, I actually started in North Minneapolis as well, and it was just the brink of bringing computers into schools. And we had our first Apple lab, and I was not at all trained in technology, but as the library media specialist, it was going to be my job to start teaching that. And it was really with the help of the kids that we discovered technology and how technology and literature can work together in a really, really beautiful way. And so for those 20 years as a library media specialist, being able to blend the technology and the literature part and research and resourcing, it was, again, just the most ideal job that I ever could have had, and bringing that to the kids and creating a welcoming environment for learning where they felt safe. I just thought it was, it really is the best job in a school if you can get it. So it is really my wish and my hope that as a state that we start to invest again in not just libraries, but those people that make it all work for the students, supporting the staff, and creating the kind of literate communities that we are all looking for. So thank you.
Go ahead.
Thank you, Mr. Chair. Senator Kunesh, I'm really excited about your bill. I'm pretty sure that whatever exists after this earthly life, like I'm going to a library, like that's where I will be. I was an early reader, a voracious reader, and it was actually our local library and librarians who would like help my mom find books that were appropriate for my age, but like also at the level that I was reading at, which was not always easy. And then I had teachers that did the same, but I also, when I got into like, oh gosh, that precocious age, like third, fourth, fifth grade, I started listening to adult conversations and writing down references I didn't understand and then bringing them to my librarian, and she would help me research what it meant. And sometimes she'd be like, we're not gonna look that up. But I mean, my like love of learning things really came from our librarians and our media specialists. And so like, thank you for the work that you do, because there's precocious little weirdos out there right now that are like writing down little stuff that they hear and bringing it to people like you. And hopefully they'll be sitting in this Capitol one day. So thank you for bringing this bill, and I'm really excited we get to do this.
Thank you.
Thank you, Senator May-Quade. You know, I just got to tell you guys, thank you, Senator Kunesh, for this day you brought to the Capitol today, this morning. I started my day with testifying about municipal libraries, and I get to end my day with testifiers about school libraries. And I, Ms. Crone, you made me think, and then you echoed it, and I can just tell from your body language, you're going to agree with this. Confucius once said, choose a job you love and you'll never work a day in your life.
Yeah.
And I just think that you three certainly found your calling because of your enthusiasm and exuberance. And it's a rare treat, and I'm sorry if I'm speaking off the cuff here, but to have a testifier be a former student of mine really brings a tear to my eye, especially one so eloquently as you were today, Ashley. Sorry, I'm using your first name, but okay. I don't even know what your last name is, because you're Ashley. Senator, your final thoughts?
Just thank you very much for giving us this opportunity to elevate the role and the responsibility of library media specialists through this legislation, and appreciate the support that you all have given us.
Okay, this bill is going to go to Ed Finance next, and so, which would be Senator Kunesh's committee. So all those in favor of sending it to Educational Finance, say aye. 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 All those opposed? Motion carries. Thank you, Senator Kunesh.
Thank you both. Thank you for coming back again today.
Senator Hauschild, you are up when you're ready. Senator, whenever you're ready. Senator Hauschild, we have bill number 1632, and we'll be re-referring it to the Committee on State, Local Government, and Veterans. Begin.
Thank you, Chair Swadzinski and members of the Education Policy Committee. Minnesota has had a strong commitment to collective bargaining. Over 400,000 of our fellow Minnesotans are members of unions, just over 16% of our workforce. In recent years, Minnesotans have been organizing in new workplaces and expanding existing unions. As we continue to depend on hardworking union labor in Minnesota, there is increased protections that our teachers and public workers need to strengthen their collective bargaining rights. Senate File 1632 addresses these protections, and I'll go through the provisions that are under the purview of education policy. Allowing our Tier 1 teachers and early learning educators to join the bargaining unit, extend due process protections to early childhood family education and adult basic education teachers so that educators of our youngest and oldest students in the public schools have the same freedom to speak out about what's happening in their classrooms as other teachers. It aligns the probationary periods between cities of the first class and other school districts so that no teacher has to spend 6 years on probationary status. It returns the probationary period to 60 days, which was previously the case before 2011 for 3 consecutive years instead of 120 days, and requires negotiations on e-learning days, which is a particular issue for our hourly workers in our schools. This bill recognizes the power of public decision-making and allows more transparency about how decisions are made for our schools. Please support the education policy provisions for Senate File 1632, and I stand ready for questions, and I do have 2 testifiers.
Absolutely. Please introduce yourself for the record, and you may begin your testimony.
Good evening, Madam Chair, members of the committee. Thank you for the opportunity to testify. My name is Meg Luger-Nicolai. I'm an attorney with Education Minnesota, and I'm here to testify in support of this bill and to thank Senator Hauschild for carrying this. Education Minnesota is strongly in support of this bill, and we believe that this modernizes and brings into our current understanding the ways in which union members, the ways in which all employees can be brought into a decision-making process. Education Minnesota supports, first of all, ensuring that there is actual conversation and bargaining occurring regarding e-learning days, which this year we've had a lot of experience with, and we do a lot of OJT, a lot of on-the-job learning about topics like that. And because there is such a significant impact on the working conditions, because it affects the school calendar, which necessarily has significant impacts on the lives of every employee in a school district, it's important for our folks to have an opportunity to have meaningful input into that process. Additionally, it is our hope to align the circumstances of Tier 1 educators with other licensed teachers. They were, as originally enacted, the language ensured that these individuals didn't get to be in the teacher bargaining unit, even though they share a community of interest with other teachers from the standpoint of the work that they're doing and the fact that they are required to have a license. So we would like to see that fixed. Additionally, we'd like to see a change to the way in which our early childhood and family educators and ABE teachers are treated in terms of their access to the same due process rights that other licensed educators have. They are at the bookends of students' experiences in the educational system. They do such critical work, but right now they don't have similar rights with respect to tenure and layoff, and there really is no meaningful reason for that distinction. So we'd like to see those individuals be similarly situated to their other licensed colleagues. This change is minimal. It does not change their status with respect to their membership in a teacher bargaining unit. They already are in the teacher bargaining unit as defined in section 179A.03 subdivision 18. Additionally, the probationary period is something that we would like to see return to the original statutory language as it existed in 2011. We've had some conversation about this, and I know that there are folks who will say that the current status, the current 120 days are working for everybody, but they are not. They don't work for women who have postpartum disorder. They do not work for individuals who serve in the military for a significant chunk of the school year. Those individuals have to repeat a year of probation. And while it's great that they don't have to start over, that's meaningless if you were already in your first year of probation. And additionally, it means that you have to do 4 years when just because of your service or your health condition or your pregnancy. And so that is something that we believe that the 60 days did represent a meeting of the interests of districts and having an opportunity to observe individuals who, by and large, will be able to serve the entire school year. That is the goal of all of our educators, but also allows for a period of observation. And again, we're only talking about probationary teachers, so this is not the entire teaching force over the course of a school year. We also support ensuring that pre-K teachers are included in the bargaining unit without any further lack of clarity around this issue. As it stands currently, whether or not somebody's in the bargaining unit depends on what their job description says. If their license is preferred, they aren't. If it's required, they are. That is kind of not reasonable. I mean, people's expectations should be firm. And so those are critical pieces that Education Minnesota supports. And if there are very specific questions, I'm always happy to be available if possible.
Chair, I have one other testifier from my district, if that's okay.
Thank you.
Good evening, Chair and committee members. Senator Hauschild asked that I attend today to testify in favor of this bill. My name is Delia Syme. I'm a third grade teacher in Proctor, Minnesota, just outside of Duluth. I'm here with my colleagues Anna Kidd and Dan Stauber. I've been a teacher since 2017 when I began serving as a much-needed substitute in my daughter's school while I went back to school to become an elementary teacher. I was leaving the practice of law after 14 years, and I couldn't have been more excited. I was one of the first cohorts in our graduate program to go through the new tiered teaching system. I was a Tier 1 teacher initially, then a full-time Tier 2 teacher, beginning in kindergarten, and then last few years teaching 3rd grade. Last year, when I became a Tier 3 teacher eligible for continuing contract rights, it was one of the most exciting days of my life. Besides spending my days with curious minds and literally the future of our world, having the right to join a union was enormous. Educators are incomparable in their selflessness and dedication to their students and their students' success. I'll mention that all 3 of us taught all day and drove down here immediately at dismissal to testify because we believe so strongly in our students' success. Our entire school system is built on this quality, and now it may be our downfall. Teachers are exhausted just when our kids need them the most. The legislature has an opportunity, indeed a responsibility, to turn the balance. This bill covers many benefits and protections for our fellow teachers and other educational professionals. We work in collaboration and continuity with one another from preschool through graduation. So having a continuity of bargaining rights is a logical and welcome adjustment to public education. Consistency will lead to greater success for our students because our teachers will have consistency in their own workplace environments and expectations. Specifically, Section 2, the negotiating on e-learning days. E-learning days may sound like an easy solution to keep students learning and teachers teaching anywhere in any conditions, but we all went through distance learning and hybrid teaching and can attest to the incredible amount of preparation, pre-planning, and pre-teaching this type of instruction requires. This can look very different if you are a secondary teacher, but in elementary school, this equates to wrangling 20 to 39-year-olds to use technology unassisted. You can imagine. For districts to require this new model of education and to be able to implement these days without educator and union input by way of negotiation is to drastically alter what teachers were hired to do, instruct children in classrooms. It also does not allow for that individualization by grade level or technology access. For example, in our district, numerous hotspots had to be used during distance learning. Those aren't easily distributed at 4 a.m. when the district calls for an e-learning day due to a blizzard. We want this to be a negotiable item so that teachers have a say in how to best serve their students in the case of dangerous weather or poor road conditions. What is expected of teachers? What of families? Will teachers have adequate time to prepare e-learning materials? Additionally, it was just a few months ago that I learned that our amazing paraprofessionals have to use their limited vacation days in the case of a snow day. They have no option to work to earn their wages. We need to address this to ensure that we are taking care of all of our school workers, hourly and otherwise. Students rely on paraprofessionals, as do teachers. We cannot attract or retain quality paras if they are not protected. Speaking to Section 5, the probationary days, most teachers spend 3 years at their first school before achieving tenure. But for many of my colleagues, it can be 4 or even 5 years. This is because state statute requires 120 days each of these 3 years in order to count to the probationary period. Many of my colleagues have had medical emergencies, whether it be premature babies or cancer treatment, or they have been called up for military service during their probation. Currently, they can get a pause on their service, but they end up teaching 4 or more years to achieve tenure. Language at Section 3.32 would fix this and would return to the standard that was in place before the 2011 legislature, doubled the number of days that were needed each year. Finally, Section 3, expanding unions to include Tier 1 and early learning teachers. This provision of the bill is very important in building collaboration and a climate of community. Our primary teachers rely on the expertise of and communication from early childhood teachers. It makes sense to include all educators in the right to unionize. I myself was a Tier 1 teacher, and I know Tier 1 teachers are providing vital instruction alongside their peers. We should not create a class system of teachers and teacher rights. It's not Minnesotan, it's not democratic, and it certainly is not in the best interest of our kids, who see their teacher as their guide in learning, regardless of their tier status. As our profession struggles to attract new and retain those teachers, slotting them in with lesser rights only decreases the likelihood that they will stay to become those highly experienced Tier 3 and Tier 4 teachers, which our students all benefit from. All educators should be on equal footing. Extending these protections and rights will protect against discrimination and bias, whether implicit or explicit, and go a long way toward improving the diversity of our educators so they reflect our student population. It will also encourage teachers like me, coming from another career or getting a later start in education, to join this meaningful pursuit. Thank you very much for your time.
Thank you. And Senator Hauschild told us you drove down right at the end of the school day today.
Yes.
Thank you. We have 3 more testifiers, so if you two could stick around in case there's questions specifically for you, we'd appreciate it. Jennifer and Tim and Scott, one of them. Come on up. Identify yourself, sign up, sign in the register, the log.
Excuse me. Mr. Chair and members of the committee, my name is Jennifer Early. I'm an attorney with Ratwick, Rozak, and Maloney, and I'm here today on behalf of the Minnesota School Boards Association, the Minnesota Association of School Administrators, the Association of Metropolitan School Districts, the Minnesota Association of Secondary School Principals, and the Minnesota Elementary School Principals Association. And the reason is because all of these entities who are in the public school system are concerned about Senate File 1632. The entities represent the interests and the voice of public schools in the state of Minnesota in multiple forums and are listened to by multiple agencies such as the courts and the state legislature. MSBA and its members, as well as these other entities I've mentioned, are stakeholders in these laws under consideration in Senate File 1632. Unfortunately, we have not had the opportunity to have a lot of meaningful conversation with the authors of these bills, partly because of the storms that we had last week and rescheduling and everything. But we are certainly willing and hoping to do so that we can sort through these. This is a very hefty bill. It has a lot of working parts. It's got a lot of pieces that coordinate with other pieces of legislation that are being proposed, and it's not clear they all work together and how they're going to gel when we get all these pieces in place. But there are several key issues that we at least wanted to bring to your attention today to say that we do have concerns, we would like some consideration, and to point to some of these issues so you have an idea that we do have something in mind we'd like to speak about. First, there are some proposed changes to the composition of our teaching staff that will negatively affect the quality of education. We fully support our teachers in the state of Minnesota. They do a lot of hard work. They're very important to us, but we also want to make sure that we have pieces in place that ensure that we have quality teachers, that we've ensured that they are well supported in the school, and that they get a fair shake when we're making decisions as to their employment status. One example I'd like to speak to is the amendments that are being required to change the probationary period of a teacher from 120 days to 60. As has already been discussed, teachers have an obligation to complete 3 years of probation at the commencement of their employment. What constitutes a year has been moderated from number of years, from an undefined period to 60 days for a very short period of time, and for the last 12 years to 120 days. Once teachers complete that time period and they move to another school, they only have to complete 1 year of teaching service. Our concerns with regard to shortening this continuing contract piece of it and what constitutes a year of service is basically the limited time that schools then have to evaluate the service that teachers are providing. It's not to say that we don't have good teachers out there. Schools have a lot of responsibility and things that they have to do during the day. They have a number of probationary teachers that they have to observe. They have to conduct at least 3 evaluations of a probationary teacher each year, and having only 60 days to evaluate the performance of a teacher is not fair to the teacher. It's not fair to the school. It's hard for somebody to come in and perform to their utmost best within 60 days and get a full picture as to their qualifications. And when you don't have that amount of time, a longer period of time to evaluate how everything is working in the school, give teachers an opportunity to listen to the comments and the observations you have and improve, you're not really listening to what the qualifications of that teacher are. As a result, when schools only have that shortened amount of period of evaluating the performance of a teacher, they get very nervous. This is a teacher that's going to be in the school district for a long period of time unless there's some type of situation where their employment is subject to termination. And they are not going to have an ability to go back and say, this isn't working out for us. We have a time period that we have to make these decisions, and it's a very short turnaround. As a result, schools have a problem in making a decision based on 60 days of observation at best if they can't get into the classroom enough times to determine what those skills of the teacher are. And for those reasons, we're going to have a situation where instead of moving teachers on and keeping them here in our school system, schools are going to be subject to that issue of making very difficult decisions to non-renew those teachers because they simply don't have enough information as to the qualifications and skills of the person before them. That's not good for the teacher because there's some very good teachers out there that deserve a better shake. It's not good for the students because they should have continuity in services and we should have an ability to evaluate our teachers and have them for a longer period of time. And it's not good for administration and the school boards because we're already having difficulty retaining staff. And if we can't make determinations as to whether we have the appropriate people in the right places, it's going to be even more difficult if we're moving them in and out. For those reasons, we feel that we really need to have that 120 days. It's been working well in this school system for this time period. We understand that there's issues with regard to claims that teachers are not getting a fair consideration of this and have to teach longer because of the leave provisions that they have. There are provisions in the statute that already take into consideration family leave, military leave, medical issues, and those are given consideration. The legislature's talked about those for a long period of time, and those have been in play. And the 120 days gives teachers gives them at least a 12-week period that they can be off, which is usually what constitutes the amount of time that people have for a normal family leave, a long-term medical leave, and takes some of those issues into consideration. But those are a lot of the issues that we really have a concern about with regard to the probationary teacher status. Another piece, and I won't spend a lot of time talking on this, but it is a major concern, are the wide sweeping and changes and multiple statutes that are addressing the data privacy pieces of the rights of an individual that will significantly impact the school's relationships with their staff. Now, I know this might not be a piece that's specifically on target for you with regard to educational services that are being provided, but they're important to the employment situation that schools have with their teachers and other staff members. We have a situation where proposals are being made that the schools are supposed to be providing a great amount of data to the unions and labor organizations that are private information that schools have to have in order to have this employment relationship with their staff. There are individuals out there that do not want their private data shared with anyone, including members of the union. We understand that the union has an obligation to represent individual employees that are within their bargaining unit. They have always had that obligation before and after Janus. The issue is that there's still people that did not like to have that information shared. And while we're looking at the interests of those individuals who would like to have their information shared with the union, that would like to share and increase those connections, there are individuals whose rights are being completely neglected by this, and those are the individuals that are interested in maintaining their privacy rights. And schools are being placed in the middle where people will not be providing this information if they're afraid of having their privacy rights violated. We would like to have some consideration of the individuals who are not being considered, and this bill simply doesn't address those concerns. We would like the opportunity to address those. The third and perhaps the most imperative issue that MSBA and its other educational association colleagues wishes to address pertain to the long-standing and governing structure of our local school boards and the proposed amendments that seek to impinge on this authority. The fact that the school board is in the best position to independently govern its schools has long been recognized by law. We have a Minnesota State statute, section 123B.02 subdivision 1, that creates school districts in general. It provides that schools shall be charged with the business of the district and the interests of the schools. It says nothing about other individuals or other entities that are supposed to have input into those decisions. In fact, the courts have gone through a number of cases, including employment labor cases and situations involving the rights of teachers and other employees, and they have continued to recognize the fact that school boards comprised of taxpayers and often parents or in the entities to whom these powers of management have invested and whose judgment should not be second-guessed. That doesn't mean there should not be input from other stakeholders. There is meet and confer. There are situations and committees that schools get input from their staff members and from other individuals with information. We have board meetings that we gather all of this information from various committees and individuals in the community, and we get that type of information to make those decisions. But when we start making amendments in Senate File 1632 to erode these inherent managerial rights, we're targeting school boards to negotiate as to how they're going to operate some of the very simple educational programs and services that they're providing, how we're going to have student-staff ratios. There are different issues with student-staff ratios depending upon whether you are in the metro district or you are outstate Minnesota. How we negotiate those and address those or make those decisions as to how many teachers or how many staff members or paraprofessionals we should have for a student is much different if you have 15 students in your class or 40 students in your class, and having a cookie-cutter determination that we must negotiate those issues with all of our teachers, with all of our staff members, is going to be problematic in having policy and programs implemented. When we're talking about the types of assessments and student testing that has to come into play, we have decisions that have to be made on a regular basis in school districts. When we're talking about having to negotiate those issues, particularly if we are dealing with the teacher's contract, the teacher's contract is very much ingrained into Minnesota Statute Section 179A, the Public Employment Labor Relations Act. It provides that teacher contracts cannot be reopened during the term of the contract. So when we're negotiating these issues as to class sizes, as to staff ratios, as to student testing, what student testing schools should and should not be providing to their students, even though it might be mandated by state or federal law, we have issues as to putting those into our contracts. When we do, we can't touch those contracts for 2 or 3 years, depending upon when a settlement is reached following that. But if we have these ratios, if we have these requirements built in the contract, we're not going to be able to address them to address changes such as what if we have another situation with COVID? What if we have a situation where we need to have something else addressed? There will be problems with regard to that. We are going to have problems reaching agreements on this. Having these types of decisions subject to grievances, subject to arbitration, is going to slow the process of imposing these types of educational services and programs. These are decisions that are time sensitive. If they're not efficiently managed, if they're not managed in accordance with the fiscal responsibilities that school boards have to abide by, it is going to be problematic to move the educational system forward in an efficient, economical, and appropriate manner that provides educational services immediately and as efficiently to students as we can. Schools deserve to retain these same inherent managerial rights. We're specifically targeting schools with regard to this portion of the legislation, and it is taking away rights that specifically are granted by the statute. And for those reasons, we would really request that consideration be given to these issues. We would like discussion with it. We would like input with it. We would be like to be treated as stakeholders and have the opportunity to address our concerns on these issues rather than having so many of them thrown at us at one time. And leaving off those points, I guess I would like to thank you, Mr. Chair, and members of the committee for the time and attention today. I've probably spent more time speaking on this than you probably wished I had spent speaking, but I appreciate your attention, and I'm glad to stay and answer any questions today if you have any.
Thank you, Ms. Early. And if you could just go through those, you went rather fast for me, all the groups that you represent tonight.
Absolutely.
Could you go through those again before you step away and then stick around, please?
Right now, Mr. Chair? Yes, I would.
Appreciate that, yeah.
And I will write them down on my list too as well here, but they are the Minnesota School Boards Association, an entity that's been vested legislatively with a number of opportunities and duties that provided by law to assist schools. We have the Minnesota Association of School Administrators. We have the Association of Metropolitan School Districts, the Minnesota Association of Secondary School Principals, and the Minnesota Elementary and School Principals Association.
Thank you.
Thank you.
Our next testifier is hybrid. Oh, yeah, thank you. Yeah, Senator Kunesh.
No, for our testifier. So you highlighted 3 different areas, and I'm really not sure in the bill which areas those were. Can you tell me specifically which areas you were speaking to?
Mr. Chair, Senator Kunesh, one of the issues is that these provisions go throughout the bill. There's a number of things that really affect them, but I could tell you that the ones that pertain to Minnesota statute section 122A.40 and 122A.41, that was specifically with regard to the probationary period. I believe that was,
I've got that. It's the second one, the data privacy, and then I'm not even sure what the third one was.
thank you. Section 1 has to do access by labor organizations. Personnel data must be disseminated to labor organizations to the extent necessary to conduct elections, notify employees of fair share assessments, and so forth. What it is often is that this piece, at one point in time, and as it currently reads, is that the responsible authority determines the dissemination of data as to when that is. Our concern is that basically there's no guidance, there's no standard as to who makes that ultimate determination. So if it's asked for, schools are essentially required to provide it, and I believe there are provisions in there that specifically also, if they're not in this bill, they're going to be in other bills too that talk about the fact that specific pieces of information about employees are being requested, and it's very vague in here as to the information that can be requested. It can be something such as the cell phone of an employee. I've had, as a representative of school districts, I also, in my practice, is not only representing these entities, but also representing a number of Minnesota school districts throughout the state. They've been subject to a number of these requests. We have social security numbers requested. We have personal cell phone numbers requested under the statute. We have a lot of information that is very private and personal that I feel employees are not going to be as willing to provide to their employer if they feel that they're going to have to disclose this information to entities that they don't know, they're not familiar with, and they prefer not to have shared. Secrecy, or not secrecy, privacy has become a center stone in the last few years that many people are holding tight to. So that would be the one provision, at least, that relates to the privacy piece that I was referring to.
Mr. Chair. And Senator Kunesh, I know do you mind if I ask a question about this piece before they move to the next piece?
Is that okay?
Yeah, of course. And we're going, do we want to do this now? Ms. Lewis is going to tell us which parts of the bill are relevant to this particular committee, if you can just hang on for that information, but then we'll get to you too. Thank you.
Mr. Chair and members, in Senate File 1632, there's several sections that deal with the education code, so that would be in the purview of this committee, and it would be sections 2, 3, 4, 5, and I believe, and 6. Those are ones that deal with the education code.
Thank you. Senator McQuaid.
Thank you, Mr. Chair. So I guess I'll ask you a technical question then. If I was going to ask a question about what was just mentioned, but it's in section 1, is that okay?
Absolutely, you have the floor.
Thank you, Mr. Chair. Ms. Early, I'm looking at section 1, and I'm just seeing that the personal data must be disseminated, but I'm not seeing any changes to any of the any of the data that is already disseminated. So I'm confused as to how there's a data privacy issue when there's already in statute laid out that personal data is disseminated, and we're not changing which data is disseminated. They just have to instead of.
It's to the extent that the responsible authority determines the dissemination is necessary. Minnesota Government Data Practices Act provides that the responsible authority makes the determination as to whether data is public or private, and whether the individual who's requesting the data is entitled to the information. All of the information that's generally being requested by labor organizations with regard to these questions is private data. There are times when information, of course, is helpful to the union in order to conduct elections, notify employees of their responsibilities. We have work email addresses. We have work cell phone numbers. We can provide, and we often do provide, home phone numbers, or home addresses, to allow them the opportunity to provide this information. They're allowed to disseminate information to the union members. Oftentimes, they have this information with their contact information that's provided to employees upon employment. But oftentimes, we get requests that go way beyond that. And for example, Social Security numbers. And I don't know about you, but I don't like to disclose my Social Security number to just anybody. So there are times when those things are requested, and if there isn't some type of determination about whether or not this information is reasonable, and there isn't some type of authority that makes that determination, who makes the decision as to whether it's reasonable or not? And when do employees get the right to make the determination as to whether their information is disseminated?
Could I just respond to that as well? But they already can access that information. Wouldn't it be, if they request Social Security numbers or things that perhaps are not necessary, don't you already have that right to not share that information?
Well, under this provision, we wouldn't have the right to determine whether or not that the dissemination is necessary. It's taking out the right of the responsible of authority to make sure that the dissemination is necessary. It just says to the extent necessary, but who makes the determination, not the responsible authority anymore.
But it says personal data must be disseminated, right? Disseminated to labor organizations to the extent necessary to conduct elections, notify employees of fair share fee assessments, and implement the provisions of chapters. You're already doing that, so that doesn't change. It's just saying that you do have to do it. It's not that there's a choice.
Mr. Chair, if I may, for the benefit of this conversation.
Yeah, and I just want to remind everybody, and we'll continue this, but section 1 will be going to judiciary.
Thank you. So I'll just offer this for the good of the order then. It strikes the word may and replaces it with must. I think that's the loss of flexibility that's being relayed here by the testifier. Right now, districts may disseminate that information with the ability, using their best judgment. This bill is saying that they will have to. And I've got a question about that later that I'll save, Mr. Chair.
Senator.
Senator Hauschild.
Thank you, Chair Swadzinski and Senator Kunesh, Senator McQuaid, and now Senator Duckworth. I appreciate this discussion, and I am certainly, as the author, and this goes for the rest of the bill as well, willing to have thoughtful conversations about how best to do this. I will say, however, the conversation seems to be on the fact that the entities, the authorities, the schools are concerned about disseminating this information. What we're forgetting here is the fact that many of these school districts under current language may not. If it says may, then that to me indicates that there could be circumstances where unions are not getting the information that they need. So there's this balance of how are we ensuring that our unions have the options to communicate with their members, and I think that's kind of where this balancing act is when it comes to this data.
Okay. And then, Mr. Chair, Senator Kunesh was on part number 3. I took that, so I'm giving it back.
I don't know what part 3 was, though. I have probation, data privacy, and then what was the third issue?
The inherent managerial rights of schools.
It's section 9, I believe.
Thank you.
Oh, and that is not something that we're discussing here in this committee. Okay, then I'll just let it go for that. Thank you.
Thank you. So we'll finish with the last 2 testifiers and then open it up. Could the online testifier? Oh. Could the online person unmute? Okay, could the, sorry, that was for my own amusement. Thank you. Could you identify yourself and then begin your testimony? Thank you.
Oh, you're on mute, sir.
You're on mute, sir.
Of course I was on mute. I apologize for that. My name is Tim Palmetier. I'm general counsel for Asa Area Schools, and I've also represented public schools for 25 years prior to this in private practice. I'm here today testifying on behalf of the Minnesota School Boards Association, the Association of Metropolitan School Districts, AMSD, Minnesota Association of Secondary School Principals, and the Minnesota Elementary School Principals Association. I'm going to follow up a little bit on some of the testimony provided by Ms. Early. I think she covered a lot of territory. But I do want to add some context to the first provision that we're talking about here, Section 1, about access to or access by labor organizations to certain information. The Minnesota Government Data Practices Act essentially accomplishes two purposes. One is to provide transparency in terms of the operation of government, and the second is to protect privacy interests of individuals. In this case, the privacy interest of personnel data of individuals. This provision, by changing a may to a must, creates a substantial change, I would say, in terms of the Data Practices Act, and would be unprecedented in terms of how much access we're affording, in this instance, labor organizations to private personnel data that an individual may or may not want released in those instances. So I think it is a substantial distinction. Next, I want to address Section 9, which deals with terms and conditions of employment. I recognize again that some of these items will be picked up by other committees. However, this is a really significant provision and really goes fundamentally to the work of public schools. As Ms. Early indicated previously, school boards are vested with the authority of the care and management of school districts. They have to make sure that their budgets work. They have to go out to taxpayers and ask for operating levies. They own this issue by right of Minnesota Statute 123B09. But I also think it's contrary to the provisions of PELRA in terms of talking about what is inherent managerial right. So matters of inherent managerial right, according to current statute, include such areas as discretion or policy as the functions and programs of the employer, its overall budget, utilization of technology, the organizational structure, selection of personnel, and direction and number of personnel. This provision strikes me as totally at odds when we talk about terms and conditions that could be included or would be required to be subject to negotiations in this instance. So according to the statute, we would require, this bill would require, I should say, that staffing ratios, class sizes in school districts and charter schools, student testing, and student to personnel ratios in school districts would all be subject to negotiations and would not be matters of inherent managerial right. I don't know how we get there from the standard definition and well-worn definition, or well-understood definition, I should say, of what it means to have inherent managerial right being exercised. And just as a practical matter, in our school district, for example, if we were to reduce the class size in one elementary grade, just one, so first grade, for example, by one across the district, the cost to the district would be approximately $1 million. So we're talking about significant impact on school districts and school districts' budget. I also think it's important to recognize that when you open the door with respect to a change and you require that something of this nature be subject to class sizes, for example, be subject to negotiations, and then inserted in the contract, you open the door to multiple grievances. I would suggest to you that school districts would incur substantial liability by adoption of this provision, because when you have an arbitration, there's always a remedy in place. Schools have to act nimbly throughout the school year when we get increases, unexpected increases, a charter school closes, and class sizes balloon in one particular school. This provision seemingly puts school districts in a very difficult position and subject to grievance arbitration and considerable liability. I do want to talk a little bit about e-learning days. the passage of the e-learning day statute was really, I think, very beneficial to students and gave school districts great discretion, gave us an alternative to the notion of what we used to do, which was throw up our hands and say another snow day. I remember a few school years ago, we had, I can't remember the number, but there was well over 7 closed school days, and many school districts were having to work with their teachers to figure out how are we going to make up time at the end of the year. If we subject the e-learning day statute to negotiations and make that, again, remove that as a matter of, and I should say, actually, the statute specifically says that we are required to consult with our teachers, and we have done that in our district, and I think we've come to reasonable positions. But if this is subject to meet and negotiate standards, we're going to see a completely different potential outcome, and likely a reduction in flexibility that we have with e-learning days, which is currently provided to us. I'm going to move past some of the comments that I was going to provide with respect to the 60 days. I think that Ms. Early did an excellent job explaining those, other than to say that I think when we try to move and define what a year might look like from 120 to 60, we know that this is a really tough job. Teaching is an incredibly tough job. And there really are, maybe there are a number of people that certainly don't have those attributes and skills to be truly qualified and good teachers. And those who maybe struggle a little bit more, we need time to work with them. But this is really important work. And I think when we reduce that window, that probationary period for any given year to 60 days, we really minimize how challenging and difficult this job is. At the end of the day, when a teacher reaches the end of their probationary period, we really need to know, and they need to know, is this the right profession for them? And I think that, as I said before, Ms. Early did an excellent job explaining that. I do want to make one other quick comment. There is, in section 7, there's some indication about redefining the definition of public employee, and I have to at least, maybe this is a moment or a space where we could actually have some conversations with the authors of the bill, but I can see some potential significant implications by changing the definition of who constitutes a public employee, and basically saying that if you work for a public school, so we're not talking about cities and counties and any other public entity, we're just saying for schools, if you work for a public school, you automatically obtain the definition of public employee. And there is certainly implications as it relates to obligations under PELRA, if that is in fact the case. But I was thinking about this from my own vantage point, and I don't know if this is intended, but and maybe someone can explain to me if I'm wrong in viewing this. But say, for example, we have a community ed teacher who likes to teach guitar and teaches multiple sections of guitar over the period of the course of the school year and during the summer. I don't know if it's intended for PELRA to attach to those particular individuals, but it certainly seems to me that those types of positions were never intended for that. And I certainly don't understand why public schools would be placed in a different position than, say, a city who might be employing someone for temporary employment. I'd be happy to take any additional questions myself, but I'm going to reserve my comments to that at this point in time.
Thanks. Well, stick around, okay? Senator Duckworth. So come back, please. Senator Duckworth, you can't wait. 2 more. Go ahead. With that long noise you.
I will explain myself. I have a
Thank
higher
you.
ed meeting still. It starts at 7 for region stuff. So if it's okay, I want to power through what I have on the bill quick, then I'll get out of here and you can finish up. So I appreciate that. And I'm not going to ask these in the form of questions like I normally would because it's late and I have to get out of here. So I'm just going to kind of pose some comments out there for hopefully the author of the bill and other stakeholders to continue to work on potentially. I think the last 2 testifiers in particular have done a great job illustrating some of the valid concerns and points that have been raised by this bill. As it pertains to line 1.10 and the personnel data and changing the may to must, perhaps something there that can be added to the bill is requiring folks to have to sign something that gives the permission to share this information. That seems to be a pretty reasonable and common sense thing to do. As it pertains to line 1.18 in the e-learning day plan, I guess my question would be, are they going to have to meet and negotiate an all-encompassing general plan for the district, or is the expectation that they are trying to meet and negotiate every time they want to declare an e-learning day? I think obviously that would not be practical. I'm hoping it's more in the general sense, and as was just shared by the most recent testifier, I think a lot of that is being done between districts and teachers unions right now at their local level to make sure that everybody's on the same page regarding an e-learning day, all-encompassing plan for the district. Moving on, when we look at page 7, line 7.5, it's defining teacher, and I'm wondering if part of the definition of number 3 here would make it so that somebody doesn't have to have a license in order to be considered a teacher under this definition. Again, that's rhetorical. I just see that as a potential, to me, it was an interesting thing to note. As was mentioned before, lines 7.14 to 7.16, the part that adds staffing ratios, class sizes in school districts and charter schools, student testing, student to personnel ratios in school districts, that's a huge deal if we're going to make that now negotiable as part of a contract between districts and teachers unions. I don't think the practical implication of what this would mean is maybe fully understood, or how that will impact the districts, their ability to do their job, and their ability to change and be flexible throughout the course of a school year, let alone a school day. So that's something that certainly needs to be looked into in more detail. Subdivision 8, I'll just be brief here, liability. And carrying over to the next page, specifically lines 8.2 to 8.10, I mean, we're essentially taking away someone's ability to seek a remedy if they desire, if they think they've been wrong. That's extremely powerful language to say that folks are essentially held harmless or can't be sued no matter what. I think that certainly needs to be looked at in more detail. I noticed there's a nice little carve out for elected or appointed officials in regard of a leave of absence. I would just be curious to see what the district's perspective is on that and how that best serves them and the kids in the classroom. Sometimes folks might be able to step away for quite a long period of time. Bargaining information, I'm on line 8.24. And 2.5, a public employer must provide the following contact information. Again, this gets back to the privacy issue, and it looks like it's not just school districts in this instance. It would be any public employer having to provide that information that's listed in this paragraph to an exclusive representative, and then continuing to do that every 120 calendar days. Again, I would hope the employer, the person the information pertains to, is giving their permission in that instance. Subdivision 9 on page, starting at line 9.7, I guess I would just sum it up by saying what, based on the language here, what can't they do? They could essentially interrupt, potentially, a school day for any reason to talk to somebody if they deem it necessary. I would like to see schools and districts in particular consulted on this, so that if they're trying to run a predictable and undisrupted school day or classroom, that they at least have a little bit of flexibility here to ensure that they're scheduling these sorts of meetings, or that their buildings or whatever are being used in a way that's respectful of what kids are doing in the classroom and not disruptive to their learning. So I guess I would just, I would end by saying this as it relates to this bill. There has to be a working relationship that respects teachers and employees while also affording districts the ability to fulfill their duty to the kids and the communities they serve. This is a give and take. It is not a stacking of the bench in favor of one party over the other. That is certainly not the role of the legislature. So there are some decent tweaks throughout this bill, but there are other sections of it that I think have major concerns and implications for districts and their ability to do what they need to do on a day-to-day basis to serve teachers, kids, and their communities. So with that, Mr. Chair, I thank you. I'm sorry for being rushed, but I don't want to get in trouble heading to the next committee, so thank you.
Thank you, Senator Duckworth, and enjoy higher ed. So we have 2 more testifiers, I believe. 1 more, and then we'll open it up. So identify yourself and make sure you sign in.
Chair, Mr. Chair and committee members, thank you for the opportunity to speak with you. My name is Scott Helen. Yes, I did do that. I'm a member of the Literacy Action Network and a coordinator in adult education. Literacy Action Network is a statewide professional membership organization whose mission is to develop, improve, and expand adult literacy services by coordinating public policy advocacy, fostering statewide collaboration, facilitating professional development, and supporting quality adult ed. LAN supports increased wages for ABE teachers, but one of the bill recognizes the professionalism and the hard work of teachers in our field of adult education, lands in favor of teachers being paid in a similar way to our K-12 counterparts. And most adult education professionals have a K-12 license rather than a specific adult education license. However, K-12 and adult education programs are funded in very different ways. Without an addition to funding to go along with the provision in the bill, our shared goal of having teachers be paid like their K-12 counterparts while working in a system that's funded at a much different rate is a difficult one. 83% of adult education budget for a program in the metro area is currently wages and salaries. Adult education programs run year-round, which is different than our K-12 counterparts and our partners. If adult ed teachers have this shift to K-12 pay scale without changing the funding of adult education, then there has to be an adjustment to the budget somewhere for these additional costs that would be 20 to 33% of an increase for programming budgets. Without an addition to the funding system and little wiggle room when 83% of the adult ed budget is staff wages and salaries, there will be limited options on how to balance the budget. Perhaps there would be fewer ABE teachers. Perhaps there will be the same number of teachers, but they would have fewer hours. Perhaps there would be program cuts serving less adult learners. None of these methods serve our clients better. The math does not deliver the same amount of service with the same funding. Currently, 73% on a different point, 73% of the programs in the state consortia are school districts, but 27% of them are not school districts. So it kind of does create a division within adult ed if 27% of the teachers are left out of this bill. Adult education programs are focused on serving the needs of students to include English, GED, HiSET, certified nursing assistant, IT career focus, paraprofessional training for schools, jobs in manufacturing, and transportation. And the hours students need in class will be less if this bill passes without any additional funding, as 83% of the budget being salaries and wages cannot withstand these costs without additional funding. Literacy Action Network has advocated for an increase in ABE for years for our teachers and programs. Senator Kunesh will be hearing this Friday, and we thank her for that. I understand that this is the policy committee and not finance committee, but wanted to hear our concerns, and it doesn't appear that the bill will probably go to finance. It's a win-win to have increased pay and increased funding for adult education in our ABE programs, and thank you. I do have one 5-sentence thing from one other person, if that is okay to read, Chair.
Go ahead. 5 seconds or 5 sentences? Okay, go ahead.
This is from Simu Aleski. She is a manager from the Southwest Adult Basic Education Consortium in rural Minnesota. She's also the president of the Literacy Action Network. While we would love to pay our teachers on the same salary scale as K-12 school districts, our funding does not reflect theirs. About 80% of her budget is staff salaries. If there is additional funding to back this proposal, then that would be a different consideration. I hope the committee will take into consideration this proposal. We don't know the exact impact today as local decisions would have to be made, but thank you for your time.
Thank you. So that's it for testifiers? Okay. Question, Senator May-Quade?
Well, thank you, Mr. Chair, and I'm going to keep my comments narrowed to what's in the jurisdiction of this committee. And Senator Hauschild, I really want to thank you for bringing this bill. Man, if you want to scare some money, let working class people organize, yeah? We have seen attacks on unions, I mean, decade over decade over decade. My grandfather was a steelworker. He was a black man with an 8th grade education, and he was able to provide for 5 kids with a stay-at-home wife and send all of them to the University of Minnesota with his union job. And his refrain, and we always joked, would be, "You join that union now." And I had to explain to him, "Granddad, that's like not how the economy works anymore. There's not a lot of unions." We have seen the erosion of the opportunity and the rights for collective bargaining just eroded and eroded and eroded and eroded. And this helps restore what has been eroded. And in particular, you know, we've had, in different committees, we've had folks that we talk about in this bill, because it's not just teachers that are part of our children's education, right? It's the people who drive them to school, it's the people who feed them, it's the people who are the paras, you know, all of these people are part of that education. And when we leave them out of the process, their voices aren't at the table, and they're fighting for our kids. And so I'm just so grateful to see this bill come forward and to see someone like yourself, Senator Hauschild, you're a champion, fighting for those who are fighting for our kids. And so this is a great bill, and this is a great time to be a labor supporter. It is a great time to be on this committee, and I'm just really looking forward to see this move forward, because our teachers have been out there fighting for our kids, and everybody else who's not included currently in this bill have been fighting for our kids, and now we have a chance to fight for them. So I appreciate you bringing this bill.
Anybody else? Closing comments, Senator?
Thank you, Chair Swedzinski and members of the Education Policy Committee. Thank you, in particular, Senator McQuaid, for your comments. I think that's spot on, and I think a lot of the concerns with this bill are things that I look forward to working with stakeholders on. I had a meeting today with, I think it was probably 10 superintendents in the Northland, in my district and surrounding region, to talk through this bill. And so I am more than open to having those conversations and making sure that we find out how we can do this right. But I would be remiss to not bring up that bargaining rights and the specifics in bills like this have also been trying to be torn away. And so I think it's really, really important that this not just be, this conversation not just be in the vacuum of the current bill, but in the context of what has happened both in Minnesota in previous legislative cycles, but also across the U.S. and other states in the destruction of collective bargaining rights. And so I look forward to championing this bill as we move forward through the other committees in a thoughtful way that considers all of the stakeholders' thoughts and feelings. And I appreciate the opportunity, Chair.
Senator, do you care to move your bill, refer it to the Committee of State and Local Government and Veterans?
I do.
All those in favor, say aye. Aye. All those opposed? Motion carries. Nice job, Senator.